The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone, and welcome to today's 5 series webinar. For those of you who haven't listened to one of these webinars before, what we do in these sessions is look at practical tips in relation to some key issues for your business. So today's session is 5 ways to protect your business from employee competition. It should last for around 30 to 40 minutes. Hopefully it will give you some food for thought as to the issues, or at least act as a refresher for you. If you do have any questions, I'm not sure I'll have time to pick them up during the session because these sessions are supposed to be short, sort of 30-minute sessions. But you can use the questions function on your screen. And if I can answer them at the end, I will. If not, then I will email you afterwards. Alternatively, you've got my email details there on the slide, so please do email me if you have any queries, and I'll come back to you. So the context of today's session is that most businesses will, of course, have key employees, whether it's your star salesperson who has very strong client relationships, or a great manager who's really loved by his team and knows how to inspire them to get results. These employees are likely to, of course, have detailed knowledge of your business and plans, significant relationships with your customers, and skills and experience that you don't want to lose. So that's all great while the employee's happily working for you, but what if they resign, or if you discover that they're planning to compete? The impact could clearly be huge if they do set up in competition or went to work for a competitor, particularly if they decide to use your confidential information and trade connections against you. Sorry, I just had a few technical difficulties there with moving on to the next slide. So on this next slide here, I've outlined the 5 areas I'm going to cover in this session. The starting point is what protection you include in the employment contract at the start of employment, so I'm sure most of you are aware. Then we're going to look at what should be contained in your policies and procedures in order to supplement the contractual position. Tip 3 on the slide there is looking at what you can do during the employment relationship to ensure that the protection that you put in place is still fit for purpose, and to make sure that the customer relationships you have are strengthened in other ways. In respect of number 4, we'll look at the risk areas in relation to employees claiming that the restrictions in their contract are not valid on the basis that the employer has breached their contract. And finally, I'm going to look at some of the practical steps you can take when an issue arises and when you should think about litigation. So first, looking at protection in the employment contract. Well, the main reason, as you may be aware, that we have contractual protection is that there's little recourse without having the protection in the contract if the employee decides to operate in competition, particularly after termination of employment. Whilst there's more protection during the employment relationship, it's still a good idea to supplement that in the written contract. So looking quickly at what protection there is at common law, and this is what's implied into the employment relationship, even if you don't have it written into the contract. Firstly, during employment, employees are bound by their duty of fidelity or to act in good faith, which would include a duty not to compete, not to disrupt the employer's business, not to poach staff or customers, and not to misuse company property. Employees are also bound by a duty not to disclose or use for their own purposes the employer's confidential information. Confidential information in this context is what an employee is either told is confidential or what is obviously confidential. So if it's not something they're told about and it's not obvious, then it may not be protected. There's also additional protection which applies in relation to those with fiduciary duties. So that would be board directors or very senior employees with equivalent status who might sit on a board and make the same kind of decisions. For those type of employees, there is a duty to disclose their own wrongdoing, a duty not to profit, and to avoid conflict. There are other fiduciary duties, but they're the relevant ones in this context. So after employment, the only protection that's implied into the contract by common law relates to confidentiality, and in the context of after the employment relationship ends, only trade secrets are protected, which is the most highest form of confidential information. So this wouldn't, for example, cover mere confidential information such as customer lists. So in that context, what should you include in the written contract of employment? Firstly, looking at obligations during employment. Fidelity. Whilst there's an implied duty of fidelity for senior and key employees in particular, I think it's worth repeating this in the contract. For example, using words such as the employee will provide faithful and diligent service to the company. In fact, it's worth including it for all employees in the contract of employment. Doing so really underlines the significance of it, so that the employee is fully aware of that expectation. The next two on the slide I'll take together. As I mentioned, at common law, these are obligations if you have an employee who has fiduciary duties, but there may be employees who are senior and who you want to be bound by this type of obligation who are not fiduciaries. So it's worth including clauses in the contract preventing them from having conflicting outside interests and requiring them to report wrongdoing. Additionally, you can have a clause in the contract which requires an employee not only to report his own wrongdoing, but also to report wrongdoing of others, which can be valuable. So again, it's worth thinking about including that in the contract, particularly for senior employees. Next, having a clause which provides that employees must not make preparations to compete. So whilst there is an implied duty not to compete during employment, this does not extend to making preparations to compete, and there's been a number of cases about whether the duty of fidelity goes that far, and it was found that generally speaking it doesn't. Therefore, it's a good idea to include a clause in the contract of key employees which stops them from making preparations to compete during employment. Confidential information. So as I've mentioned, during employment by common law, confidential information is protected if employees know it's confidential or it can be reasonably regarded as confidential. But that said, to ensure that everyone knows what is confidential information, it's a really good idea to set it out in the contract of employment. Normally, a confidential information clause will apply during employment and after termination. And as after termination only trade secrets are protected, this is even more of a reason to make sure that the contract clearly specifies what is confidential information. So what I'd recommend is that you really apply your mind to particular types of information that are important to your business, whether it's particular customer lists or databases, supplier terms, for example. Really think about the kind of things that you want to protect. Having a specific clause will always be better than having a general clause relating to confidential information. Next, I think it's worth including a duty on employees to comply with your policies, particularly on IT use. I'll go on to talk about what these policies should say, but critically they should prevent, for example, transfer of confidential information onto personal devices, misuse of IT systems, etc. So including that kind of obligation in the contract will tie employees effectively into the policies. Garden leave. There is no implied right to put an employee on garden leave, so unless you have an express right in the contract, you can't require an employee to stay at home and not carry out their duties during the notice period. So it's best that an express right to do so is included. This is particularly because if you were to otherwise put an employee on garden leave and you didn't have the right to do so, they may claim that you've breached their contract and then that any post-termination restrictions will fall away, which I'll come on to in a bit. Next, right to return company property, either on request or on termination or at the start of the garden leave period. This is a really useful clause to have in the contract because it would allow you, for example, to require company properties such as laptop and other IT equipment to be returned if you suspected employee competition. You could then inspect it for evidence of wrongdoing, obviously subject to your rights to carry out monitoring of devices, etc. Inclusion of a pile-on clause, so that's a payment in lieu of notice clause. Should consider having one of these in the contract because it allows you to lawfully terminate an employee's employment without serving notice. So you can exit an employee from the business quickly if you want to, without being in breach of their contract. As I've said already, the risk if you otherwise do this would be that you breach the contract and the restrictive covenants are no longer valid. Finally, I mentioned social media. What I would say is that the case law on social media is very much still developing, including on who owns social media content, particularly if the social media sites are personal. However, you could include a clause requiring delivery up of any blogs or details of contacts made during employment on social media sites where those sites relate to the business of the company. Can't guarantee that will be enforceable, but there's certainly no harm in including such a provision. So looking now at restrictions after termination of employment, I think most of the audience will be familiar with the kind of restrictive covenants that I've put on the slide. Obviously, there's no implied post-termination restrictions, so it's important to think about whether you do need these in the contract. What I've quite often seen is contracts which have, for example, a non-compete clause and a non-solicitation clause, but there's no non-dealing clause. And I always think it's worth having a non-dealing because evidentially it's often easier to demonstrate that an employee is dealing with one of your customers after termination of employment as opposed to solicitation. And by dealing, I mean actually doing business with the customer. So, you know, in that context, having solicitation alone might not be enough to catch the activity in question. Other restrictions that you could include include prohibiting an interference on your relationship with suppliers. In my view, that kind of restriction on relationships with suppliers is only likely to be valid to the extent that the interference damages your business. So, you know, clearly, if there's a relationship with a supplier which is developed and that has no impact on your own business, that's unlikely to be actionable. So it should be where the interference causes the supplier to cease or reduce supply with you. So when drafting post-termination restrictions, the enforceability very much depends on how they're drafted. The starting point, as you may be aware, is that restrictions on competition are regarded as unlawful restraints of trade unless they go no further than is required to protect your legitimate business interests. So in that context, it's necessary to look at both the duration of the covenants and also the scope of them. So, for example, a business should not require a restriction to last any longer, really, than it would take you to employ a new employee in the role of the departed employee and establish a new relationship with the customer to the point where you can say that your business won't be damaged by the employee leaving. The shorter the restriction, the more likely it is to be enforceable. There's no rule of thumb, but there's been lots of cases where between 6 months and a year has been found to be enforceable for senior management positions, but clearly this still depends on the position. And restrictions on competition are clearly the most difficult to enforce because they may prevent an employee from working in their chosen sector and therefore from earning a living. Another point in terms of scope is that the restrictions must be specific to the employee's activities. So, for example, a restriction on solicitation of customers would need to be limited to the customers that the employee had a relationship with in a particular period before termination or has confidential information in relation to them. The same applies in relation to restrictions on poaching employees and potential customers. So it's only those employees that the employee in question has had a relationship with. If you attempted to prevent an employee from poaching any customer of the business, this is probably going to be unenforceable unless, for example, the business is very small and the employee has relationships with all the customers. In terms of what's going to be reasonable, it's clearly going to vary from business to business. And my view is it's generally best not to have an overly ambitious approach, as this could be found to be too restrictive and it could weaken what is otherwise a valid claim in relation to employee competition. Some of the considerations are on the slide, including whether the employee will have access to confidential information or intellectual property, if their departure would have the potential to damage relationships with key suppliers and prospects, how long it would take to rebuild the relationship, what the business cycle is. So, for example, if your contract renewal period is annually, then it may justify a longer restrictive period. And also, would others follow the employee to a new employer? So those are the kind of things you need to think in mind when drafting the restrictions, but they need to be tailored to the employee in question. And I'd advise against including general restrictions in a contract. Obviously, the best time to include these restrictions in the contract is at the start of the employment. I think this is important for two reasons. Firstly, your bargaining position is likely to be strongest before the employee starts. And secondly, if restrictions are included during employment, then unless they're done on promotion or as part of a pay increase, there can be a problem with consideration, which means they're not valid. So the consideration at the start of employment is the offer of employment itself. Same cannot be said for an introduction during employment. So number 2 tip is ensuring that your company rules and policies protect your business. I think the most important policy is likely to be your IT and communications policy. So within this, you can set out rules on prohibited use, including removing any confidential information from the company IT systems. This is important not only in terms of protecting your confidential information, but obviously also from a data security point of view. You should also include the fact that you will monitor emails and IT use, the basis for that monitoring and the extent of it. Generally, my view is that employees should not be allowed to use their own personal devices for work purposes, although I appreciate in smaller businesses sometimes that isn't always practical. So if you do allow personal devices to be used, ensure that you have a carefully thought through bring your own device policy, which should include, amongst other things, measures to ensure data security and to require return of any documents, confidential information and contact information on termination of employment and or on request. Finally, I've mentioned privacy notices there, which unless you've been having stuck with your head in the sand for the last 6 months, you'll know is a reference to the GDPR. As I'm sure you're aware, this is coming into force on the 25th of May, so next week, I believe. And there's a requirement under the GDPR to provide much more detailed information to employees about the purposes for which their personal data will be processed, and also the lawful basis which will be relied upon to process data. It's generally accepted by most of the employment law community that you won't be able to as easily rely on consent to process personal data, and you'll need to rely on one of the lawful bases in the legislation. In this context, it's likely to be that the processing is necessary for the company's legitimate interests, or it's necessary to comply with legal obligations. So in your privacy notice, it will be important to refer to the fact that emails and IT use may be monitored and the lawful basis for doing so. Next, I just want to talk a little bit about ongoing review of protection and relationships. So you've got your employee in the role, they're all signed up to the contractual terms, which is great. That's not the end of it though. During the relationship itself, I think there are a number of steps that can be taken to protect your business if the employee leaves. Firstly, customer relationships. Although you will want your employees clearly to build strong relationships with customers, this does increase the risk of customers following when they leave. In view of this, I think it's advisable to regularly review how you manage client relationships and to ensure that customers have relationships at all levels of your team. Likewise, it's worth thinking about team structures to make sure that customers are not overly reliant on one individual. Exercises such as team get-togethers with customers can be useful in developing bonds between customers and your business at all levels, for example. And then it's worth thinking about the level of protection you've got in the contract where you have a change in role. So it may be that you have an employee who has no protection in their contract, but they're promoted to a role where it's necessary. Or it may be that there's an employee with that protection, but it needs enhancing on promotion. That's the time to do it when the employee is promoted, because then you'll have the consideration in relation to introducing those new restrictions in the contract. So tip 4 is to be alive to the risk of employees claiming breach of contract. I've already mentioned that by law, if you as an employer seriously breach the contract of employment of your employee, any restrictions which are in that contract will fall away. So this is clearly a risk in the case of employees who seek to claim that their employer has seriously breached their contract by their actions and therefore they're no longer bound by their restrictions. I think in particular what you need to look out for is employees who may have become disenfranchised and may be thinking about leaving to go for a competitor. In this context, there's a risk that they could allege that your treatment of them has somehow breached their contract. I think the best way to protect yourself from the situation is to be alive to the kind of potential issues which could in turn amount to or be alleged to amount to a serious breach of contract. Frequently in this context, the implied duty of trust and confidence, which is in every employment contract, is relied on when alleging a serious breach of contract. So the type of issues to look out for are things like allegations of overwork, stress at work, lack of support, or an employee's position being changed or undermined. If these types of issues are raised, I think you need to ensure they're dealt with promptly and effectively, as always in the employment relationship, and that you also pick up on the issues by regularly meeting with the employee or their line manager so that you're aware of how things lie on the ground. This in turn should help you to deal with them before they reach a point where an employee might have grounds to allege that there's been some serious breach of contract. Importantly, it's important if there is a grievance to deal with it promptly, because failing to deal with a grievance in itself could amount to a breach of the implied duty of trust and confidence. Finally, on this slide, I've mentioned having a pile-on clause. If you have a pile-on clause or a garden leave clause, make sure you exercise it in line with the contract. So, for example, your garden leave clause might permit you to do certain things but not other things. Clearly it's best that your garden leave clause is very detailed and that it covers everything that you want to do. For example, requiring the employee to remain at home, requiring them not to have any contact with customers, suppliers or colleagues, perhaps requiring them to report to you regularly. If you go beyond the extent of the garden leave clause, then it might be alleged that you're in breach of contract. Similarly, with a pile-on clause, one of the things to look out for is whether an employee under the pile-on clause is entitled to basic pay only or also to pay in lieu of benefits for the pile-on period. So again, you need to make sure you follow the letter of the contract to avoid breach. So if you discover that one of your key employees is going to a competitor or thinking about it, if they've resigned unexpectedly or are acting suspiciously, what would you do about it? These next couple of slides will look at some of the steps you could take, both legally and practically. I think the first thing is that it's important to react quickly. Often in these situations, time is of the essence. So you need to think quickly about what you want to do strategically and whether or not you need to get some advice. I think it's very important to think about your strategy first, because quite often in these situations, emotions can run high, and it's important that those emotions don't wag the dog, so to speak. This might be a good opportunity to convince the employee to stay. So I think the first step would be to talk to the employee. Even if they don't want to stay, it would be an opportunity for you to find out where they're going and what their intentions are. Aggressive confrontations in this context clearly aren't helpful, and an amicable conversation might mean that the employee is more inclined to play ball and to do right by you by handing over any company documentation when they go and abiding by their contract. Conversation would also allow you to pick up on any discontent and work out if the employee is likely to try to allege that you've breached their contract, for example. The next step would be to look at the contract, see what the protections are in it, see if you can take it further if you need to. If necessary, you might need to take advice on the enforceability of the protections. Bear in mind also that if they're a shareholder, there may be protections in the shareholder agreement in addition to the employment contract. You might want to think about placing the employee on garden leave, as we've already talked about. Garden leave is a useful step because it's a lot easier to enforce than a post-termination restriction, albeit you are clearly having to pay the employee for that period of time. So if you have reason to suspect that the employee might be in breach of his or her restrictions, or maybe contemplating do so, then the next step is to gather evidence and to retrieve company property from them. Evidence might mean talking to other staff. It might mean carrying out searches of email, telephone and printing records. You might want to check when in the day the employee has accessed your premises and IT networks, and if there's any evidence of unusual activity. If there are serious concerns, you could consider using a forensic IT specialist. This can be very useful in that they can conduct searches of files that have been deleted or downloaded or overwritten, and they'll know how to preserve the evidence. So it's highly recommended if you view it as being a serious issue. But bear in mind, if you are carrying out searches, in order to comply with data protection laws, you should make sure they are proportionate to the evidence that you're seeking, and ideally in line with a monitoring clause in the contract. So if you do find evidence of competitive activities, the first reaction might well be to dismiss the employee without notice for gross misconduct. I think you do need to carefully consider if this is your best option. For one reason, once the employment has ended, your employee owes you fewer obligations and they are more difficult to enforce. A better, albeit more costly option would be to put the employee on garden leave. When I say more costly, it'd be more costly in the short term, but in the longer term, it may well be less costly than trying to enforce the restrictions. Dismissal is also a fairly risky course of action unless you have a nailed-on case. So unless you have very, very clear evidence of wrongdoing, which is serious enough to dismiss, the employee may allege that the dismissal without notice is a serious breach of contract, meaning the restrictions fall away. Therefore, I think if you are contemplating dismissal, it's best to take advice first. A further option, rather than dismissal, might be to agree an early exit with the employee on the basis that they provide you with assurances that they will not breach their restrictions and abide by their contract in return for your agreement not to dismiss them for gross misconduct. That kind of approach would ideally be done via a settlement agreement. So I think in the context of when an issue arises, it's very easy to concentrate solely on the employee and focus all your intentions on them and their actions. But remember not to forget to focus on your customers and your internal teams. Let your customers know who will be looking out for them. The notice period of the departing employee is likely to be a good time for consolidating relationships. Same goes for your internal teams to make sure that they feel loved and they know the direction that the team's going in. And if appropriate, you might want to consider an internal and or external announcement about the employee's departure. So if you do get to the point where you're considering legal action, the first step is usually to write to the employee and their new employer if they've left, notifying them of their contractual obligations and requesting an undertaking that they comply with them. Quite often these are given in my experience, and then you can move on with things. The significance of undertakings is that if there is then evidence that they are breached, you have a good case to go to the courts on the back of them, as the employee has breached an undertaking that's been given recently and specifically in relation to those restrictions. That's not to say that you couldn't go on the back of the contract itself. It's just when presented with undertakings which have been recently given and are breached, courts tend to take a fairly dim view. If you do need to take action, then this can be very expensive, as I'm sure you'll appreciate. So it's a question of weighing up the cost against the benefit, which is likely to involve taking legal advice. There will be a requirement if you go to court to give what's known as an undertaking as to costs to the court, so that they know that you're good for it if the case is successful. Obviously, if you are successful, costs will be recoverable, but you're unlikely to recover all of your costs. So if the matter cannot be resolved successfully through undertakings, then the immediate consideration is whether to apply to the court for an interim order to maintain the status quo pending a full hearing. Interim injunctions are sought at emergency hearings on very short notice, a few days, if that normally, and if granted, they can order that the employee immediately ceases his wrongdoing, e.g. misusing your confidential information or data or soliciting or dealing with your customers. If you're successful, your former employee and perhaps his new employer will be served with a court order and with stark warnings of the consequences of their breach, coupled with the demand for payment of legal costs. If the dispute then continues, because sometimes the interim injunction can effectively knock the matter on its head, but if it carries on, then the matter is likely to be listed for a full trial within a few months under the speedy trial process. So instead of a normal, fairly lengthy litigation process, everything is compressed into a very short period, which obviously can be expensive and time-consuming, not to mention stressful. If you do end up going through that process and get to the stage of a final order, then the objective is to obtain an order that the employer will comply with his obligations together with an order for damages for breaches. If also you have an employee who's a director or in a similar senior position, you could obtain an order that he will account for any profit he has made as a result of his wrongdoing, which is a stronger remedy than damages. So that's worth being aware of in the case of directors. So, as I say, I think litigation very much is the last resort, and quite often these matters can be resolved through undertakings. But in some cases you will potentially want to push the button, but it's very important that you take advice and weigh up the cost versus the benefit before doing so. So just to conclude, clearly it's not possible to prevent employees from leaving as much as you might hope that certain employees won't do so. But I think you can improve your position significantly if you consider and plan for the risks associated with departing employees in advance by looking at putting in place proper protection in the contract, policies which back that up, by reviewing that throughout the employment relationship, and then through acting quickly and strategically if an issue arises. So thank you very much for listening today. I hope that was helpful. I can't see that I have any questions. I'll just check. No? I can't see that I have any questions, but if I have missed any, then I'll make sure I reply afterwards, or otherwise please drop me an email and I'd be quite happy to pick up with you. As ever, very happy to receive any feedback on this session. Please either email me with feedback or contact the marketing team at gunnercooke with your feedback. It would be greatly appreciated. Thank you very much.